seated, please. Welcome, everyone, and thanks again to the Court of Criminal Appeals for letting us use the call. Two cases on the docket this afternoon. The first is Appraisal Review Board of the Harris County Appraisal District versus Texas Workforce Commission. Who's present for the appellate?
Redona.
And appellee?
Will be going for the appellee Texas Workforce Commission.
You got time for rebuttal? All right, you may proceed.
May it please the court. This case raises an important issue for the state, for all of the large appraisal districts throughout the state who have a lot of work to do in a relatively short period of time every year, but then for about 6 to 8 months of the year, there's very little to do. And the legislature sets this up because the tax rolls have to be approved by a certain time. All the tax protests have to occur within a certain time. And so the folks who serve on the appraisal review boards of our district, as well as those in these large counties, have to in effect overhire for the peak tax protest period. And then during the off tax season, there are a lot of people with very little to do. Our legislature has set it up to where they are paid on a per diem basis. So unfortunately, unlike with school teachers, we can't structure their compensation to even out over the course of the year. They're paid per meeting that the board is convened, and then that's it. So we're sort of in a jam with this, and I think a few of these folks know enough about the law to be dangerous, and so what they've done is they figured out that they can go over and apply for unemployment compensation and get the appraisal district to, in effect, supplement their income with unemployment compensation during the lean months. Our position is that the statute doesn't require that what we view to be unjust result, and also a result that is not in consonant with the purpose of the unemployment compensation statutes.
Which statute says you can't do that?
I'm sorry, Your Honor?
Which statute says you can't do that?
Okay. Let me start with Section 201.091E, which the Supreme Court in the Wichita County case referred to as an exception.
Labor Code, correct?
I'm sorry?
Of the Labor Code, correct?
That's correct, Your Honor.
I mean, you guys deal with this every day. I do not.
Okay, yes.
So let's be specific, if you will.
It is of the Labor Code. Yes, Your Honor. All right. It says, for purposes of this subtitle, an individual is not considered unemployed and is not eligible to receive benefits for any benefit period during which the individual works the individual's customary full-time hours, regardless of the amount of wages the individual earns during the benefit period. Okay. This statute then, what it's doing is it's saying that if you look at a benefit period, and benefit period is a defined term under 201.011.4, 7 consecutive days. So we're not looking at, what do they make, how many hours are they working during the peak period, and then we compare that to, well, they've dropped off to only one meeting a week, and so shouldn't we analyze it in terms of 40 down to 8? But that's not how the statute's written. It's written in terms of a benefit period, and it's written in terms of customary full-time hours. So what are customary full-time hours? We think in terms of the Labor Code, or the Fair Labor Standards Act is requiring up to 40 hours a week as full-time work. But customary full-time work for this employer is what the legislature has dictated is the workload for this particular governmental entity, and that is they have a peak period when they are going full blast. 40 hours a week is common, but then when the off season hits, there may be 5% of the caseload is what's left, and then it trickles down to even less than that. So they may get one hearing a
Is full-time
week.
defined anywhere?
I'm sorry?
Is full-time defined?
It is not.
It's not,
And I
right?
looked, and I don't see that it is defined. So full-time.
I guess my concern, and maybe it's that customary is doing the work here, is that usually if there's not a statutory definition, we have to go to dictionaries. And I think full-time, most people would commonly think of that as 40 hours. And so is it the word customary that's doing the work that's changing maybe the ordinary meaning of full-time?
Well, but the statute
Right.
says the individual's customary full-time hours. It doesn't say, what most people.
But she would be doing full-time at a different time of year. She would be doing 40 hours at a different time of year, just not this time of year, right?
And we're talking about a pay period.
Right.
We're talking about, a seven-day pay period within the meaning of the word pay period. And our pay periods drastically differ depending on what time of the tax season you're talking about. So my view of it is that this untoward result that the Employment Commission has decided in this case is appropriate is very easily fits within this exception in the statute.
So the argument would be, for appraisal review board member, your customary full-time hours in the off-season is 8. Well, I guess it's per week, so tops 8.
Yeah, they may get one meeting a week.
Yeah, and so, if they're getting 8 hours, that's customary for that line of work.
That's right. That is their full-time, that is full-time for that particular point in time.
Of course, all the rest of the statute, 201, base period is you're looking at huge amounts of time, base for the last 5 quarterly periods, and then it's either bigger or much smaller because it's benefits per week, and that's the benefit amount is figured. But so it's just, in your view, the question is whether customary is requires, and I guess TWC decides that in the first instance, and then with the appeals process and all that.
I think that the term customary is not defined in the statute either. Dictionary meaning of customary. You look at what's usual per the circumstance, the specific circumstance. And the specific circumstance here is dictated by a very intensely regulated tax protest process, where all this has to, this isn't like, I think that we had the restaurant analogy where, or a clothing store.
Christmas tree sales, 100 things I can think of that are up and down and on and off. And according to the briefing, this has never, except for the Redona case, this has never been decided what that means in season, with regard to, never been applied in seasonal work.
Yeah, this one is a sui generis matter. It's an unusual. This is an unusual employment situation because taxes have to be the tax rolls have to be certified at a certain point in time, and all the protests have to occur within a certain time. And it's not like your common private businesses that can structure their compensation packages to allow for the pay to be equalized.
And I assume this is not just a Harris County problem. Like, I assume this is a issue for any ARB member of any county in the state. I mean, or is it different in Harris County?
Yeah, the counties have different number of taxpayers and average different number of protests. We use one of the, I think it was Loving County or one of them that they may have 6 protests a year. Dallas County or Bexar County or Harris County, they have 500,000 people file protests, and then over 100,000 end up in these formal ARB proceedings.
Friend of a friend says he considers it a blood sport in Harris County. Every year you contest your appraisal, and every year you get a little bit knocked off. But we can't say, I guess you can't tell ARB members when they sign on, look, and you can't apply for unemployment compensation.
I don't believe that would be appropriate at all. I mean, they can certainly apply, and there would be situations.
Statutory right, I don't know if you could waive that one or not.
Yeah.
It's,
That there would be situations where the law would apply. For example, if you terminate somebody without cause, and there are procedures to remove these folks, and so if they want to contest that, hey, I didn't have my hand in the cookie till, or I wasn't, there was no conflict of interest, or whatever they get fired for, they could contest that and then presumably receive the benefits. But our point is that when the reduction in hours comes about as a result of the statutorily dictated reduction in the workload for these huge ARB boards in the big cities, particularly when we do have to overhire to cover all the work, that the unemployment compensation system should not be used to come in and say, well, yeah, the statute says I get per diem pay, and they've told me from the get-go that that's all I get, but if you reduce the hours by a certain amount.
we're forced to do this by statute. That's an exception to the chargeback issue, not an exception to whether you get unemployment compensation.
It's harder to get an act of Congress, so to speak, than a reasonable opinion from a court that I think can construe this language to yield that result on this special set of facts. This is, our case is going to be a very unusual case, but it will affect a lot of boards around the state.
Well, I guess my question is, if we were to give full-time, just very hypothetically, this customary aside, if we were to give full-time, it's kind of more common meaning, looking more, at 40 hours a week or something. I mean, there's no rule that says a plaintiff can't take advantage of a badly written statute. I mean, there's room for the legislature to fix it if they think it's really wrong. I guess my question is, can we truly be faithful to the text here and come to what seems to, maybe a more logical result? But it certainly seems like the legislature could have fixed it with some better language if they'd wanted to.
They could have. The trial court in our case made a few findings that, or not the trial court, it was the appeal tribunal. Made a few findings for which there is no substantial evidence. For example, that they are hired on a 2-year term with an average hours of 40 hours a week. I mean, the evidence that was before the trial court and before the ARB, there's no evidence to support that they get 40 hours a week. I mean, that's just not the case. And I don't know what you'll hear from opposing counsel, but there's no evidence on the record to that effect. And then that the employer reduced her hours. And again,
This is, basically par for the course. She's doing the same thing that everybody else is doing, right? Yeah.
They convened three judge panels to hear these tax protests, and it depends on how many tax protests. If y'all had no appeals, you wouldn't have any work, but you'd still get your salaries. But here, if there are no cases to hear,
Would that were true.
if there are no cases to hear, that the job duties don't involve, well, you can go clean up or something. There's nothing for them to do under those circumstances, and so we're not reducing their hours like the employers do. In the short amount of time I have left, I do want to cover the other issue, which I think is even a clearer statutory provision, that at least the ARB, the taxpayers of Harris County, don't get left with the bill to pay the unemployment compensation. That it would apparently, I guess it would be statewide. The legislature makes the mistake. You would think that would be just, but the provision on the chargeback, that if the statute requires that the reduction in work occur, which we've shown that it has very clearly, and it's not like that we have any discretion over this, then we shouldn't be saddled with the chargeback. And that's my second point. I would rather the court use the exception that's available in the statute and construe it to catch this type of narrow situation than to say that, well, you don't get charged back, but still it's unjust to put this additional expense on the taxpayers of Harris County when if the state has passed a law that doesn't accomplish what it's intended to accomplish, the taxpayers of Harris County shouldn't be made to pay it. I mean, the Loving County,
Who will pay it?
I assume that it would come out of I'm not sure which fund of the state government would pay it, but that the chargeback wouldn't come from us.
Is unemployment not funded by employer contributions?
Yes, I assume that's right.
All right,
I see my time is about up.
thank you. Mr. Cohen?
May it please the court. At the end of the day, this is actually a pretty straightforward appeal of a TWC unemployment benefits decision that's governed under the substantial evidence de novo standard. The labor code defines unemployment in this state to include partial unemployment if an individual has his or her wages fall beneath a certain threshold. In this case, the TWC had a reasonable basis to conclude that Ms. Redona Hall, who's the co-appellee, couldn't be here today, she's a teacher, couldn't make it up, that her hours fell beneath that threshold, and there weren't any other exceptions that would have disqualified her from benefits. The commission applied the plain language of the statute to the undisputed facts in this case, and substantial evidence supported that decision. That means the law requires affirmance.
What is the commission's definition, to the extent it has one, of customary full-time hours for her?
That's a great question. And I think when you look at that phrase, you have to look at all four words. It's customary full-time hours. Now, the phrase in itself isn't defined in the code. Mr. Viata was correct about that. However, there are other sections of the labor code that define a full-time work week as 40 hours. Black's Law defines full-time as usually 35 to 40 hours. So I think when you're looking at an individual's customary full-time hours, it is, yes, that individual, it is customary, but it's full-time. It's what would commonly be defined as full-time work. So something in that arena of 35 to 40 hours, Justice.
But is it, by using the term customary, is legislature signaling that we look what's customary to that individual employee?
It is customary to that individual employee, but I think that's modified by full-time. It's not just customary hours, it's customary full-time hours. And I think Justice Ferris pointed that out, that full-time does have a specific meaning. Even if that entire phrase isn't defined in the code, you have to look at all four words. And in this case, the commission saw that she was working an average of about 40, that dropped to about 8. So that's about an 80% reduction. So I think there is a reasonable basis here for the TWC, who has the authority to make that kind of determination, that she wasn't working her customary full-time hours anymore.
Is it a defined term, full-time? I'm not finding it.
The customary full-time hours is not defined. There is a different section of the code, it's Labor Code 408042, which defines a 40-hour work week as a full-time work week. And that's for a different area. It's for computing a individual's average weekly wage, but that's just one section of the code that does talk about what a full-time work week is.
Thank you.
So the standard review in these cases is substantial evidence de novo. Justices might be familiar with that, but at the end of the day, it means that the appellant has a pretty high burden. They have to show that there is zero reasonable basis for the decision, or that it was somehow arbitrary or capricious. As long as there's substantial evidence, which is anything more than a scintilla, the law requires that the decision be affirmed. In these cases, the TWC is the fact finder. They have the authority to attach whatever weight to whatever pieces of evidence are presented to it, and they can make credibility determinations.
So we are modified here in that it's substantial evidence, but it's actually based on what happened in the trial court. Is that not correct?
So when a court is looking in these types of cases, they're looking to see if there's a reasonable basis for the underlying TWC decision. So the trial court's really only conducting a review if there's a reasonable basis. So in this case, you are looking at what the trial court did, but as long as the trial court found a reasonable basis, that is, a average person could could reasonably agree with the decision, the court does have to affirm it. So it's a little bit of both, Justice.
Okay, so just make sure I understand, because I did think it was a little confusing in the briefing that this is a modified substantial evidence review. I took it to mean that the trial court could actually hear additional evidence if he or she chose to.
It is de novo. So yes, you could hear additional evidence that maybe say wasn't available or known at the time of the initial TWC hearing. But again, the court's just looking to see, hey, was there a reasonable basis for that decision? Hey, even if I might not agree with all of it, as long as there's some reasonable basis, I have to affirm it. So it is a pretty high standard to get those types of decisions reversed by the appellant in this case, or anyone trying to reverse a TWC decision. So
Is it a reasonable interpretation of the statute, in your client's view, that you compare what a per diem employee works at a certain time of year compared to the prior years? In other words, it'd be their customary full-time. Could full-time not mean 40 hours a week? It actually mean customary full-time for that employee?
So yes, I do agree. It could mean customary full-time for that employee. You are looking at the individual employee. However, I do think full-time does have a specific meaning in the labor code and a common definition. So I think you can't just look at customary hours. Again, you have to look at customary full-time. So I think in this case, the TWC did find, hey, she was working an average of 40 hours a week. That's customary full-time. That dropped to 8. That's the sort of determination that TWC can make, because it hears evidence from both parties. It heard testimony from Ms. Hall and the board. It saw evidence. It saw schedules, handbooks, calendars. So that's the kind of decision it can make, looking at the evidence that was presented to it by both the ARB and Ms. Hall. And it decided that, in fact, no, Ms. Hall, she wasn't working her customary full-time hours when she dropped to that slow season.
Yeah, I mean, some of what appellate courts grapple with is the ripple effects of what they decide. How, with TWC's argument it's making and the trial court's findings, how is every seasonal employee not entitled to unemployment during the off-season?
So I think the answer to that is if they meet the threshold, they are. I think any employee in Texas, if they're working a job that has a seasonal basis where there's going to be a slow period.
The threshold, what do you mean?
So that's a great point. So Labor Code Section 201091 has sort of a formula for when a person becomes partially unemployed. And it's a pretty technical definition. I can read it off. It's essentially if that individual's wages payable for that benefit period are less than the sum of the benefit amount the individual would be entitled to receive if they were totally unemployed, plus the greater of $5 or 25% of the benefit amount. So it's a kind of technical math definition. But I point out here that I don't think the appellant or anyone's sort of challenged the decision on the basis that, hey, Ms. Hall technically wasn't meeting that definition, that she was partially unemployed on the basis of hours.
No, I agree, but I can't imagine why it wouldn't apply to Christmas tree lots and firework retailers.
I think it absolutely would, Chief Justice, if they're meeting that threshold and they're not falling under any of the exceptions, like they were fired for cause or they voluntarily quit, something like that.
Are there opinions that I guess involve, not necessarily like a Christmas tree salesman, but something kind of more on, I mean, this is a very unique job, but is there a type of opinion that, like, say it comes up all the time with this particular type of employee that would be maybe somewhat analogous that we could look at here?
So it is sort of a unique situation. I'm not aware of any decision that specifically points to, hey, they're part-time, so we're going to analyze in that benefit. I can point you to the Wichita County case, which I think Mr. Villada mentioned, which says, and I'll quote it directly, an individual qualifies as unemployed if his or her wages are low enough. So that's what you're looking at. You're looking at the amount of wages they're making in a specific period. That's the real, threshold here as to whether Ms. Hall or anyone is qualifying for unemployment benefits, partial or not.
So, but it's never come up before.
I don't know on the top of my head, Chief Justice. It's been specifically in the context of partial unemployment.
Who would know better than you?
Good point. I can tell you that when you're looking to determine if someone's partially or totally unemployed, you're looking at the statutory definitions, and there's no case law on point that says you don't get partial unemployment benefits. No, you can be partially unemployed in the state, and you can get partial unemployment benefits if you're meeting the plain language of the statute, if you're
And is
following
it
in
right
that
that there's
category.
2 trial courts that have come out different ways, and there are also abated cases that are pending on this?
For this case specifically?
Well, on this issue.
Yeah, so there are multiple, this TWC and ARB does have multiple cases that are abated right now
Yeah.
that are pending the resolution in this one. In terms of, like, I think Mr. Bigot said, this specific instance with an ARB, it is a sort of issue of first impression. There hasn't been anything that's decided on this specific employer.
Interpretation.
Yeah. I will say, however, to that point, in 2017, there is the Harris County versus TWC case, which establishes generally that, hey, ARB members are employees and they are eligible for
Right,
benefits.
right, and so that may explain why none of this came up before, at least with regard to ARBs, because everybody thought they weren't, but, I mean, I get your point, statutes mean what they mean, but, we do need to consider the consequences, and if I like Christmas tree lots, but everybody else may not, but, if every Christmas tree lot has to pay their workers not just the $10 or $15 an hour plus tips that they make, but also unemployment for weeks and months thereafter, and basically hold them over. And I think ARB is a little different. They want to keep these people around because they're highly trained, and so why shouldn't they be like teachers where you pay them so they don't go do something else? And maybe Christmas tree lots, I'm not concerned, but there's a lot of people out there doing lawn services and Christmas tree lots and all this stuff, and if all of a sudden we basically raise the cost of employment to double it because of permanent unemployment compensation, we're going to hear about it.
Absolutely.
And you will too.
My docket will be full, but I think what might be a little different in, say, that example where someone works a Christmas tree lot. Usually those sort of Christmas tree lots, they're closing by January. So it's not a scenario where you're going to have a worker who's still working March, April, May, and applying for partial unemployment benefits.
Yeah, but you pick the highest of any of the previous 5 quarters, and that's going to be the one that includes Christmas.
Sure, and absolutely, and I guess my response to that is a little bit, hey, the labor code allows this. The labor code allows for partial unemployment benefits. The legislature set it up that way, and the TWC, hey, we're tasked with, protecting employees in the state, and sometimes that means they are going to get partial unemployment benefits, and that's just sort of the way it's written. I think if you look at that 2017 case, similar arguments were sort of made there, and the TWC's attitude in that case was, well, again, the labor code, there's nothing special in either the labor code or the tax code that says ARB members aren't employees. I think that's the same here. There's nothing special in the tax code or the labor code that doesn't allow for employees like Ms. Hall to get benefits in this specific scenario. I'm certainly sympathetic to the ARB, and it might be a situation, like you said, Justice, where, hey, next legislative session, they need to go through and amend or clarify some of this language, but as it stands today, here, Ms. Hall getting benefits is allowed under the labor code, and any other ARB employee member who files for benefits and doesn't fall under one of those exceptions, it's allowed. They can get benefits. That's perfectly okay.
They have a second argument, which is that even if you find this is an underemployment situation, the statute is forcing us into this. And I know the main counter is Retama, which I think is distinguishable. So what in the statute makes their argument incorrect?
So I think you're referring to the chargeback argument with the Retama case. So I think the key phrase there, in which Mr. Viata pointed out, that's required by statute. And I'll give you an example of when I think the chargeback protection would kick in and the ARB wouldn't get charged. So if Ms. Hall had served the entirety of her term, like she did here, but she waited until after her term was over to apply for benefits, and she got benefits, that's a scenario in which the ARB would be protected, because in that situation, her separation from employment, her term ending, was directly required by statute, because the statute says, hey, your term's 2 years, it ends, so even if she gets benefits in that scenario, she can't go, or the ARB can say, hey, look, the statute requires that her term's over. That's required by statute. So I think that's sort of the key example of when the protection would kick in. Here, what we have is a reduction in hours. We have a partial separation from employment because her hours were reduced. And Ms. Hall would admit the state's admitted that, yeah, that's because there's a seasonal nature, it's busy and then less busy, but that's not a specific scenario in which the separation is required by statute. Now, there absolutely is a calendar of deadlines the tax code lays out that Mr. Viad pointed out. We don't dispute that, but those are any employment decisions that get made as to individual ARB members, that's all gonna be downstream of those calendars and deadlines that are laid out in the code. There's nothing that says, individual ARB members have to get a minimum number of hours or a maximum number of hours, a minimum or maximum number of assignments. So in this specific scenario, and it's a little weird, but in this specific scenario, the chargeback protection does not kick in because, again, nothing about the reduction in her hours was required by statute, or it wasn't directly required by statute if you're looking at the Redona case.
I guess the key, the word to interpret there is required, because, the statute is setting them up, so to speak, for failure, right? You're required to hire enough people to get you through the busy season. They're required to give them 2-year terms, and they're required to give them per diem pay, which necessarily means that in the down season, they're gonna have too many employees, not enough hours, and there's gonna be unemployment benefits. So how is that not a requirement?
So I think what's required by the statute are the deadlines they have to meet, that they have to get a certain amount of work done by a certain period. And there's certain time periods in which, people who own homes in Harris County can get a timely, hearing of their challenge. That's what's required. Any employment decisions that they're making in terms of the individual ARB members, again, I think that's all downstream, or to quote Redona, that would be an indirect consequence of those statutory provisions. Because in Redona, I'm sure you've read, that was a security guard who got laid off because the horse racing track closed early and they got permission from the Texas Racing Commission to do so. In Redona, they said, okay, well, yes, you were required by statute, to get permission to close, but that doesn't affect the actual employment decision you made as to the security guard. I think similar logic applies here. You have someone like Ms. Hall, yes, unfortunately, there's a schedule where she's going to be working less later in the year, but again, the only thing that's required by statute are those deadlines, or in a scenario where she finished her term and then applied for benefits. Well, in that case, the separation from employment is required by statute. I think that's the key term, is it's separation of employment that's required by statute. That's the two things I think you have to look at for that chargeback issue. So unfortunately, I do think this is, admittedly a little bit of a weird scenario, but as the statute has written, it doesn't protect the ARB from chargeback in this specific circumstance. So to affirm here, the court really needs to only answer one question, which is, could reasonable minds have reached the same conclusion as the commission? And I think in this case, the answer is yes.
Not really on statutory construction.
Well, correct, absolutely, Chief Justice Christopher, and I think you're looking at the reduction in her hours. I think that is something that reasonable minds could conclude. And I also do think there's a reasonable basis for the TWC's interpretation of the statute here too, that Ms. Hall both qualifies for benefits and that the ARB is unfortunately not protected from chargeback. So I do think there's a reasonable basis on both the facts and the law here.
Here, what do we make of this section, I guess 207045, the voluntary departure, or
The
here
voluntary
kind of,
quit exception.
Yes, and it does say left the individual's last work voluntarily, so maybe it is really talking about quitting, but to me it seems like, and this is just, I guess, a guess, but I would assume people seek out a job like this maybe for a particular reason. Maybe, they've got a house somewhere else in another state that's a lot prettier at certain times of year or something, and maybe they want to, or maybe they've got, some other type of, university teaching,
Sure.
something like this. I mean, this seems like it would appeal to a particular kind of person who maybe doesn't want a 40-hour schedule
Absolutely.
all year long. So why wouldn't this kind of kick in and take care of everything?
So I think the voluntary quit, that's really good. I'm glad you brought that up. So voluntary quit, the logic there is, okay, if you're working a job and you quit for your own reason, then yeah, you're not going to get unemployment benefits in most cases, because you quit voluntarily. I think here the key factor is Ms. Hall served the entirety of her term. She served the entirety of her term, of her 2-year term from beginning to end. She didn't submit her resignation until the very end of her term. that became effective on the last day of her term.
But I guess she voluntarily took the hours drop. I mean, she knew at least what she was getting into.
Sure, absolutely. She and I think she testified to that too. That
Yeah,
yes, I knew coming in that there's going to be a busy season and a slow season. But I think, there's no foreseeability exception anywhere in the labor code. The fact that coming into a job like this that yes, my hours might go down later. There's no exception that says you don't get partial unemployment benefits in that case. And I think the voluntary quit exception is really looking just, hey, did you quit your job voluntarily or not? And the answer here is no. She served the entirety of her term. So I think by the plain language of that statute and the plain facts of the case, she didn't voluntarily quit. She served the entire amount of her term. Even, some portions of that term were going to be at a lower hour rate than other parts. So in this case, the commission applied the correct law. It relied on substantial evidence, and the trial court correctly affirmed. It did not, and it should not have, reweighed the evidence. It came to the correct result, finding a reasonable basis for the decision. The ARB today asked the court to rewrite statutes, create exceptions, and override agency fact-finding. The law does not permit that. The commission applied the statute as written, the plain language of that statute, and reached a reasonable conclusion. Under substantial evidence review, the decision must be affirmed.
Do you have seasonal employment at TWC?
I'm actually work at the AG. We're the reps for the TWC, and thankfully,
Does your client have seasonal employment?
So that's going to depend on the job, obviously, but no, most don't. Most are salaried employees. So,
Not your problem, not their problem.
TWC is always looking out for employees in the state, and even someone like Ms. Hall, I think she deserves her benefits here. So we ask the court to affirm the judgment of the TWC and the trial court.
Thank you, Mr. Cohen.
All right, in my short period of time, I want to come back first to the chargeback provision and then try to tick off some of these other arguments. First of all, I wanted to clear up what I hear to be a distinction between termination-type decisions and reduction-in-work-type situations. And I think from his perspective, the requirement phrase would only apply if they are required to give up their jobs because they're term limited out, but it wouldn't apply to reduction in work where the statute says you must have all the hearings within a certain period of time and then there are no more hearings, and the statute doesn't give the ARB the authority to have people clean up and do odd jobs during the off season. So it is required. It's absolutely required that the work is very heavily weighted towards the protest season, and then it necessarily falls off drastically, and especially in these large counties where they have to overhire. That's one point. I heard that he referred to this as employment decisions. Again, this is not an employment decision. The employer here has no control over how many hearings are held, just as this court has no control over how many people decide to appeal their cases. The discretionary aspect of this, like in the case that they were citing, this is involved a business decision to cut back because there wasn't that business. One of the findings of fact that were made in the agency was that it was because of a falling off of business that the employer here cut back her hours. That doesn't fit this set of facts. All right, the customary full-time, not statutory full-time, the individual's customary full-time hours, and it is not eligible to receive any benefits for any benefit period. That is a week. Each benefit period is a week during which the individual works the individual's customary hours. So what they want to do is say that, well, it's all 40 hours a week, and so when her customary work week during the off season drops down to once a week, that's her full-time her full-time schedule. And it was customarily her full-time schedule, and we have evidence in the record to show that. There is no evidence to support the appeal tribunal's finding that she, on the average, worked 40 hours a week, and that the employer dropped her hours as a business decision. That doesn't fit this set of facts. They
So
were
full-
applying,
sorry.
they were applying your standard old private employer paradigm to a unique statutory setup where.
Well, I suppose there's a business decision, you could decide to hire them all for the business season, let all but 20 or 30 go for the rest for the off-season, hire people back the next business season. So why isn't that a business decision? Not to do that because you want to keep them all on board. So you
Well,
don't have
because
to hire a bunch of new people.
they are hired for a certain term, Your Honor. I mean, we don't, if they're not terminable
No
at will.
discretion.
And we can't hire them just for Christmas season and then, y'all go back to school in the off-season. They are they are officials for that 2-year period. And then they're eligible to renew twice or three. They can have 3 separate terms, so 6 years total. But once they're there for 2 years, and we can't fire them at will, only for cause. All right, so that again, we don't have discretion. Then finally, the voluntary exception, where the employee voluntarily leaves work. Let's see. Yeah, voluntarily leaves work. Okay, so she accepts when she takes this job, and the statutory scheme is all explained to her. That you have a peak season and you have an off season, and she knows it, and she admitted it on the record in every proceeding she was in. That's the term of her employment. And so when she voluntarily accepts a job that necessarily by law drops off when the tax protests are all completed, she has also voluntarily accepted that reduced work schedule. And so we would argue too that is yet another way in which this court can write an opinion that makes sense from the standpoint of these types of entities having to deal with these particular labor problems. I see my time is up. Thank you for your patience.
Thank you very, very much, Mr. Beata. The case will be submitted. We'll take a brief break.
All rise.